In a groundbreaking trial, a Michigan jury found a school shooter's mother guilty of involuntary manslaughter in the deaths of 4 students that happened in 2021.
Prosecutors say Jennifer Crumbley failed to tell Oxford high school officials that her son Ethan had access to a gun. After a meeting where school staff expressed concerns about a violent drawing, Ethan was allowed to stay in school. Shortly after, the teen pulled the gun from his backpack and shot 11 people.
And WCNC Charlotte's Meghan Bragg joining us in studio right now to verify if a verdict like this could ever happen in North Carolina. Meg?
Well, guys, definitely a historic ruling after the mother of the Oxford school shooter was found guilty of involuntary manslaughter. No other parents in the U.S. have ever been found guilty of that charge in connection to a school shooting that their child committed. So we're asking, in North Carolina, can parents be held responsible if their child is the active shooter at a school? Let's verify.
Our sources, Giffords Law Center, North Carolina's Child Access Prevention Law, and attorney Gary Monty. According to the Giffords Law Center, there are no child access prevention laws at the federal level, and federal law does not generally require gun owners to safely store their guns. However, there are laws in 26 states that bar parents from allowing children access to guns. North Carolina is one of those states.
And the responsibility with the firearm is to keep it secured, particularly away from minors, and then to not do unreasonable things with the weapon that could result in someone being harmed.
Child access prevention laws, also called CAP laws, allow prosecutors to bring charges against adults if a child gets their hand on a gun. They take a variety of forms. According to North Carolina law, a parent or legal guardian may be held liable if a minor brings a gun to school and shoots someone if the parent or guardian knew or should have known the minor's likelihood to commit the act, had the opportunity and ability to control the minor, and made no reasonable effort to correct, restrain, or properly supervise the minor. Attorney Gary Monty says parents in North Carolina could potentially be charged with involuntary manslaughter, elevating the charge to a felony.
You give the weapon or make it available to the child under those circumstances, again, to anyone for that matter, then you could be charged with involuntary manslaughter, which is a felony.
So we can verify that, yes, in North Carolina, parents can be held responsible if their child is the active shooter at a school.
And guys, when we first reported on this just a few years ago, there were 31 states that had CAP laws. As mentioned, it's down to 26. South Carolina was not on that list previously and still isn't today.
All right, thanks for that update. Very pertinent to remind people of the laws here. Thanks, Megan.